What's up, everybody? Welcome back into the episode of The Lawyer You Know. And today we get the order on Donna Adelson's post-trial motions to interview jurors and for a new trial. We broke down the motions before. She had a bunch of problems with what the jurors said and how the judge acted throughout the trial, including calls that he made on people in the gallery and decisions he made surrounding her right to remain silent or to testify. And did he pressure her? Did he force her? Well, guess what? There's brand new information coming out in this motion where the judge cites the sidebars and information and arguments and discussions that we never heard before that completely changes the way I look at this topic entirely. So we're going to go through the judge's order, see if we agree with him, if we disagree, and then we're going to read a bunch of the transcripts of those sidebars to see what really happened before the arguments that were made in front of all of us, in court and on stream. So make sure you guys hit that like button. I'm pumped you're here with me early this Saturday morning. Super excited. It's the weekend. Let's get to it. All right, so we're going to start here with the order denying defendant's post-trial motions. And the denial is not a surprise at all. I think most of us saw this coming. But the reasons why and the information that is now part of the record, actually, it was always part of the record, but now we know about it because it's public, because the judge is citing to those transcripts, is going to change the way we look at this, or at least the way I look at it. The defendant seeks to interview two members of the jury in her case, jurors 5 and 7. In moving to interview jurors, the motion must set forth allegations that are not merely speculative, conclusory, or concern matters that inhere in the verdict itself. Okay, and we know there's a big difference, in my opinion, looking at juror number 5 and juror number 7. Let's see if the judge feels the same way. Consequently, juror interviews are not permissible unless the moving party has made sworn allegations that, if true, would require the court to order a new trial because the alleged error was so fundamental and prejudicial as to vitiate the entire proceedings. Defendant's allegations do not establish a prima facie case of jury misconduct, but instead encourage the court to engage in a procedure disapproved of by the Florida Supreme Court. We don't want to interview jurors, right? We don't want that to be the norm, but sometimes it is necessary. The judge found not here. The argued reason for interviewing juror number 5 is that he considered how the defendant reacted to the evidence and testimony during trial. However, defendant also notes juror number 5 expressly stated he did not consider her reactions during deliberations. Defendant's motion concedes that juror number 5 said he did not consider defendant's reactions when deliberating. The challenge primarily concerns that juror number 5 observed defendant's reactions during her trial. By operation of fundamental, procedural, and statutory rights, the jurors are present in the same courtroom as the defendant. It is not impermissible for the jurors to visually observe the defendant over the course of the trial. The Supreme Court found the fact that 3 jurors briefly viewed a defendant in his jail uniform was insufficient to warrant a new trial. The facts alleged here fall short of the argued prejudice found as insufficient in Phillips. Accordingly, the defendant may not have leave to interview juror number 5. That was the easy one. Seeing the defendant in their jail uniform is much worse, obviously, than what happened here. We knew that was going to be a slam dunk, no way, big loss for Donna Adelson, and no surprise there. But let's get to juror number 7, which was the more interesting one. Not necessarily that she did anything wrong, but would the court allow an interview? The argued reason for interviewing juror number 7 is that she posted on TikTok that she was selected as a juror on August 26, 2025. The defendant provided a video recording of this post, and the court was able to locate the post on the juror's TikTok account, where it remains an active post as of the filing of this order. So many of you commented on my last video that she did not delete it. That's a problem for the defense. If you're going to say something happened, you better be able to back it up. You better be able to prove it. Now, maybe she made it private or deleted it and brought it back up. I don't know what happened, so I don't want to make accusations against the jurors or the defense attorneys. But if the defense attorneys were dead wrong or didn't do their research or were purposely wrong, that's a major problem and an ethical problem. I don't know that to be true. The judge said, and I think completely based on how the defense, set it up, that this video existed and I was able to see it myself. It is not hidden. There is no consciousness of guilt on the part of the juror at this point with this post. It displays the following text over video of juror number 7. When I told God I needed a break and he makes it so I am selected to serve on a jury for a 2-week trial. Won't he do it? Along with a caption that reads, no work, no kids for most of the day. You know what? Heaven, yeah. And that's exhibit number 1, and they have that exhibit all the way at the bottom here. Let me just pull this all the way down. So these are the posts that he pulled, okay, from her TikTok. The jury was instructed, and here we go. We're going to get into some of these quotes, but we're also going to read them specifically from the court's transcript. Not to communicate with anyone, including your fellow jurors, and then he puts in italics, about this case. No communication includes no emailing, text messaging, tweeting, blogging, or any other form of communication. The court concludes that juror number 7's TikTok's posts do not constitute communication about the case, which is what we said. Rather, it was a comment about her jury service and its length. It does not reveal the parties, the attorneys, the alleged crimes, whether it's a civil or criminal case, or even the location of the trial. In other words, it was not about the case. As such, it is not juror misconduct. The TikTok post was not, quote unquote, so fundamental and prejudicial as to vitiate the entire proceedings, which he's citing the Johnson case. Furthermore, every prospective juror was informed. If you are picked for the jury, you may tell people that you have been selected for the jury and how long the case may take. We're going to read some context around some of these quotes. However, you must not give any information about the case itself or the people that are involved in the case. Defendant did not object to the jurors being able to disclose that limited information. That's always a problem as the defense. If you're not going to object to something during trial or when it's all happening, then you're going to argue that it's an appellate issue later. That doesn't jive usually. That's not something that works well. Accordingly, the defendant may not have leave to interview juror number 7. The motion for leave to interview jurors is denied as to both 5 and 7. A motion for new trial and renewed motion for judgment of acquittal, contrary to the law or the weight of the evidence and judgment of acquittal. The court does not find the jury's verdict in contrary to the law or the weight of the evidence. When considering the rule, motion for new trial based on the weight of the evidence, the court must exercise its discretion to determine whether a great amount of credible evidence supports an acquittal. The court must weigh the evidence and determine credibility, just as a juror would. Omitted. The court concludes the greater amount of credible evidence supports the convictions. The court relies on its previous rulings. All direct and circumstantial evidence admitted. The evidence demonstrating the defendant's consciousness of guilt and its own credibility determination of the witnesses. Stated succinctly, there is evidence in the record demonstrating overt actions by the defendant in furtherance of the murder for hire scheme. Simple, to the point, right? And we all knew this. The members of the conspiracy may have more than one objective. The trial evidence demonstrates the defendant's objective for the crimes being completed as separate and distinct from her son, the middle woman, and the triggerman. However, their combined acts resulted in the crimes committed and death of the victim. Because the objective of certain co-conspirators here was obtaining money through criminal acts, the death of the victim did not terminate the conspiracy until the co-conspirators received their payments. The trial evidence established defendant's connection to those payments. Thus, based on the unique facts of the murder for hire, defendant's case is distinguishable from Williams. The court also denies the renewed motion for judgment of acquittal, relying on its denial of defendant's initial motion for judgment of acquittal, all direct and circumstantial evidence admitted, and evidence demonstrating the defendant's consciousness of guilt. To me, very simple, very easy, straight to the point, the simplest explanation the judge could possibly have for why he's going to deny this part of the motion, and that's exactly what he did. I don't think anybody should be surprised at that. I think that's the part of the motion we skipped because we knew it was going to be simple, and that's exactly what the judge was going to say. The decision of any matter of law which arose during the trial. The court does not find error in refusing to admit the complete 2014 and 2023 planners. The state introduced particular entries from the two calendars. Defendant asked to introduce the complete calendars during its case in chief. As an initial matter, the request was untimely under section 90.108. Usually that's not reason enough to do it based on the circumstances in this case, but although the plain language of the statute requires the adverse party to introduce the other part of the statement at the time that the first party introduces the statement, Florida courts have generally allowed the adverse party to delay introducing the other part of the statement until cross-examination. Defendant's request was too late because it came after cross-examination of the relevant witnesses. Even if the request was timely, it was improper because the purpose of the rule of completeness is to avoid the potential for creating misleading impressions by taking statements out of context. By its very nature, a calendar/day planner is divided into a series of pages corresponding with the days in a year. Thus, the court concludes the entries the state admitted into evidence were not out of context. They were not one part of a whole. They were specific dates in the calendar referencing specific events. So he's basically saying each day is its own thing, and the entry on that day is what's complete, not the entire year of the calendar or 2 years. And those relevant entries were admitted. Interpreting the rule of complete to allow for every other entry in the calendars would require the contemporaneous admission of any written or recorded statement that might cast light on an admitted statement. Using the language of Section 90-108, fairness does not require turning a trial into a voyage on a sea of hearsay. Accordingly, the defendant's invocation of the rule of completeness was properly denied. I actually like that argument for the judge. I think appellate counsel for the defense might have a good argument there as well. For the timeliness, I don't think is a good argument by the judge, but each individual day versus I would have liked to see specific entries they felt were necessary and relevant to come in the rule of completeness. And I think if there are some in there, appellate counsel may be able to put a decent argument together. Moreover, the court permitted the defendant to use the entire set of calendar entries as a demonstrative exhibit during her closing argument, and defendant argued the state did not want the jury to see them. In addition, the 2023 calendar entries defendant sought to admit would not rebut arguments that she was fleeing to avoid prosecution when compared to the vast amount of contrary evidence that existed beyond the planner, such as, inter alia, defendant's text messages, WhatsApp messages, Google searches for non-extradition countries, recorded conversations, emergency fast-track visa, and one-way ticket to Vietnam. If he could just sum up the consciousness of guilt, I still think there is an argument against this that the defense might use in their appeal. All right, for other cause. Now we get into some of the other good parts. The court does not find the arguments presented in this claim to warrant a new trial, specifically addressing the defendant's decision not to testify. The court relies on the trial record. After the defendant had closed her case, but prior to the commencement of closing arguments, the parties were asked to approach at sidebar. See attached Exhibit C. We are going to read that, don't worry. The court explained it had performed additional research and wanted to confirm the defendant did not want to testify. Good job by the judge, and that's exactly what we said. Judge, in an abundance of caution, please make sure if the defense wants to reopen their case, please allow them to. We didn't think that happened, but we always say we don't know everything and we don't know what's happening at sidebar, so it's impossible for us to have the full context. But the judge went home, did more research, probably started to wade in the waters that we were in, saying, Judge, make sure she's had enough time. Make sure they can talk about it. Give her that one last chance. What does it hurt to have her take overnight? It seems like he didn't say that, but that's, I think, what his research was showing. But what did the court do? Well, the court confirmed the defendant did not want to testify, meaning gave her another chance. The court added, the reason why I'm bringing this issue to the party's attention is only because I believe the appellate cases of this state make clear prior to the instructions and closing, the exercise of the fundamental right leans towards allowing the defendant to reopen her case in chief if she wanted to testify. It's almost like he took it out of a Lawyer You Know video and quoted it in this motion. And I will tell you right now, it makes me so happy that he did this. So happy that he protected Donna Adelson's rights, that he did the right thing as a judge, no matter how annoying it may have seemed during the trial, no matter what anybody's feelings may have been, no matter how guilty she may have seemed, the judge did the right thing. I applaud him for that. I am not one bit surprised Judge Everett did the right thing. It was a little weird in some of the context that we saw in open court, but now it makes more sense when we start to figure out what they spoke about at sidebar that we didn't get to hear. I love this. I love this. I love this. And I love a fair trial. I want a fair trial. I'm a big fan of justice. And guess what? This makes this verdict all the more secure because Judge Everett did this at sidebar, which is on the record. It's as if he did it in open court. We just didn't get to hear it. Upon the court's inquiry, counsel responded, we talked to her for a somewhat lengthy period of time last night over the phone while we were prepping. She informed Ms. Fulford and my paralegal, she felt secure in her decision. I can tell you right now with a ton of confidence that her decision not to testify, will not be a very powerful or likely successful appellate argument, which is completely different than how I felt before reading this order, because we did not know about this conversation between the court and the defense and additional confirmation by Donna and her defense team. And this was after the colloquy and after she's like, I wish I could talk to my lawyers more. And after, threats were made and things like that. Defendant was then placed under oath and asked if she was absolutely firm about this decision not to testify. The defendant twice responded, yes, I am, but asked for a few minutes to talk to counsel. And what did the court do? He granted them Even after all of the threats and the pushing, and you're going to do it now, and you've had plenty of time to think about this, he gave her an additional 30 minutes. And after the time elapsed, the defendant once again stated, I have made a decision. I am not going to testify. When asked if she was firm on this decision, the defendant answered, I am. I hope this is a learning experience for everybody, understanding the importance of a criminal defendant's rights, highlighted by Judge Everett here. He went and he did some research, and he saw a defendant has to be firm in their decision. They have to make an intelligent waiver. It has to be a voluntary waiver. They can't be forced or coerced or pushed into doing it. And it felt like that the day before. But when reading this, it checks all the appellate boxes. Kudos to the judge for protecting the record. The court concluded, I will make no further inquiry unless the state or the defense seeks for the court to do so at this point. Neither party did. Accordingly, the defendant was provided sufficient time to and did make a knowing, voluntary, and intelligent decision not to testify. In denying the defendant's other allegations, the court relies on the complete trial record for its findings. So another thing they argued about was the stuff going on in the courtroom and people making, noises or whatever may be in the courtroom. When we read some of the transcripts the judge cited to, you'll hear how he answers that bell as well. All right, so first part we're going to read is page 12. So the first couple things we read are going to be about the jurors and what the court actually told the jurors, and did juror number 7 violate any of this based on the instructions? Then we'll get to the right to testify and the decisions made by the judge. All right, so this is during jury selection. All right, now that we've settled the issues of who is eligible to serve and actually remain, we're going to proceed with the process this morning. The first thing that we are going to do is to discuss what you may know about this case, if you've heard anything at all. This case has received some publicity, and there also was a related case that took place almost 2 years ago. This process is going to be handled individually because you will not need to know what others may already know concerning this matter. However, before we start the questioning, I'm going to give you some very important instructions. This is right at the beginning. Many of you have cell phones, computers, and other electronic devices with you. Even though you have not been selected as a juror in this case, there are some rules you must follow about using your cell phones, electronic devices, computers from this point moving forward. You may not use your phones or devices to search the internet or to find out anything that is related to this case between now and when you have actually been discharged from jury selection or jury duty. You must not provide or receive any information about your jury service. Okay? So this specifically says no information about your jury service. So if I'm an appellate lawyer and I'm going to quibble and pick some words out, that's something that might be important to me, including friends, coworkers, and family members. You may tell, okay, here's another thing. The judge cited parts of it, not exactly this. If I'm an appellate lawyer, again, I'm just trying to nitpick here and think of what arguments could be made. You may tell those who need to know where you are, that you've been called for jury duty. Did her entire following on TikTok need to know where she is during the pendency of this case? Is it prejudicial? Is it material? Is it misconduct? No, but can you try to start to argue? That's what lawyers do sometimes, that, she did violate some of the judge's rules and orders. We'll see. If you're picked for the jury, you may tell people that you have been selected for the jury and how long the case may take. Now, this line I think he quoted without the context here sounds better for her. You may tell people, but this one says you should only tell people who need to know where you are. However, you must not give any information about the case itself, which she didn't, thankfully, or the people that are involved in this case. She didn't that either. You must also warn people not to try to say anything to you or write to you about your jury service or the case itself. This includes face-to-face interactions, phone, or computer communications. In the age of electronic communication, I want to stress to you that you must not use electronic devices or computers to talk about this case. Okay? Is talking about that she's a juror, talking about this case, depending on the context of which sentence you read, I would argue not. I think there might be an argument from some that say maybe even just saying you're a juror is talking about this case. I would disagree. This would include tweeting, texting, blogging, emailing, posting information on a website or chat room, or through any other means at all. Clearly would cover TikTok. Do not send or accept any messages, including email or text messages, about your jury service. Don't send messages about your jury service. is her sending out a TikTok, sending a message about her jury service. You must not disclose your thoughts. I know everybody's going to be saying no in the chat, but I want to hear your answers to this. What do you think if you were to look at this? You must not disclose your thoughts about your jury service or ask for any advice on how to decide the case. She did not do that. Furthermore, you must not listen to any news accounts about the case until you have been excused in this matter. Please avoid the newspaper, television broadcast, particularly the local news stations. Also avoid any social media or any internet news sites concerning this matter as well. She definitely did not avoid any social media, but did it concern this matter? And you guys are just getting to see in a lawyer's brain, right? How you can look through this and be like, whoa, maybe that, it depends. I could argue this or I could argue that. I'm sure people are going to notice my Pabst Light, Pabst Blue Ribbon, PBR. If you're a fan, let me know in the chat. I have no idea. I don't think I've ever tasted it. You know, guys know I don't drink, but one of their chief marketing guys is a fan, reached out on LinkedIn, sent me a whole swag box of golf stuff. It's amazing. I can't remember if we ever did an unboxing. I'm going to text John. If we didn't, we will post an unboxing. It was one of my favorite swag boxes I've ever gotten with golf balls and gloves. And you guys know a way to my heart. Anybody who sends me some golf swag, you know I love that. All right, let's jump ahead a little bit more now. Page 19 here. All right, sidebar conference. And remember, we didn't get to see or hear this. In researching some matters last night, and here we go. This is some of the new stuff that the judge cited to as far as the colloquy as to whether or not Donna Adelson was going to be able to testify or whether the judge forced her hand. We heard some quotes. We're going to read a chunk of it here. In anticipation of moving into closing today, I did want to confirm with the defense the defendant is not asking to testify. Now, some would say, what do you mean asking to testify? You forced her to say no yesterday. This isn't usually how it works where she's like, oh, I have to ask to testify. But the way the rules are, like we said, protect the record. If she wants to testify, you better go ask that judge to reopen your case. Let him say no, because that's an appellate issue. It's exactly what we were talking about. Mr. Zellman, the defense attorney, says, we talked to her for a somewhat lengthy period of time last night. So we know, because this could have been another appellate issue if they're like, Judge, we didn't get to talk to her anymore about it because you said absolutely not. No, as knowledgeable defense attorneys, as these seem like they were to me, they're like, listen, we still have the chance to do this. We know what the case law says. We know how the judge sounded, but we can still do this if you want to. So let's discuss it. They took the night, which I think was totally appropriate. They did discuss it with her more and were able to get her firm decision here. She informed Ms. Fulford and my paralegal, they had taken her off speakerphone at that point, that she felt secure in her decision. If Your Honor would like us to have Ms. Adelson come to the bench, I can have her. The court said, just have the bailiff bring her over. Yes, sir. Ms. Adelson, before we move into instruction on the law and the closing arguments this morning, I once again want to confirm with you that you are firm in your decision, that you are choosing not to testify. Some could argue he's telling her that's what she's doing, and it's a leading question. No, he asked the lawyers open-ended. The lawyers are her advocates. If they want to say, absolutely, Judge, let's let her testify or let's talk to her more about it, which I think is coming. Yes, Your Honor, I am firm in my decision. You are absolutely firm. Yes, I am. Is there anything further you need to speak with your attorneys about? This is a very different tune than we heard publicly in court on the stream. This is the correct tune. This is a proper discussion and explanation by the judge. This is proper consideration. And you know what? When you offer it to her again, what does she say? I would like a few minutes to talk to them. Yes, if I could. As to this particular decision or something else? This particular decision. Now, this is after she says she's firm twice, but the judge said, I'll provide a few minutes. After this, we do need to resume timely. Yesterday, when the court made reference to contempt, okay? Because it's funny, the defense lawyers made these arguments already knowing this sidebar took place, so I don't really get it. But that contempt was one of the reasons that, you know, I think the judge that came on my show as well said, these are some issues, and Judge Carroll, and because we heard him say, oh, contempt and whatever, that seems like forced coercion, but he says, yesterday when the court made reference to contempt, this concern has continued to occur, and also not returning from conferrals. We need to resume court. So he's trying to pacify the contempt thing yesterday by saying, listen, we need to do this, but I will give you some time. If you need to speak with your attorneys now concerning whether you wish to testify, I'll allow you to do so. I'm going to give you 10 minutes to accomplish this. When 10 minutes is up, we need to move on. Judge, is it your intent to go right into instructions and closing at the conclusion of the 10 minutes? It would be my intent. Ms. Kaplan said, I would request 30 minutes because I need some more time to get my closing act together. So maybe that can give a little more time to the defense to do what they need to do as well. Both parties need to share their closing PowerPoints and demonstrate with each other as well. So that 10 minutes becomes 30 minutes, which is great. And the judge says, we'll bring 30 minutes. And then we're going to read this last quote. The reason why I am bringing this issue to the party's attention is only because I believe the appellate cases of this state make clear, prior to instructions and closing, a request to open the case or for the defendant to testify, the exercise of the fundamental right leans toward allowing this to occur. I am giving her this last opportunity to confer with counsel and make this decision. So she got an extra 30 minutes, a lot more conversation the entire night, which I believe she deserved. And obviously, the judge eventually agreed with me, even though it seemed like he didn't agree with me. Eventually, he did. He let her even have the opportunity to testify after that overnight discussion with her lawyers. Given what was brought up yesterday, that there was either, okay, so this is now touching on something he didn't really talk about in his order, but that the defense did argue in their motion that stuff was happening in the gallery. Given what was brought up yesterday, that there was either murmuring or some sort of improper influencing or attempt to improperly influence the jury, that is not going to be permitted. You will be removed and also subject to contempt. So he throws that in there and says, you better not do that. He's keeping control of the courtroom, which is once again exactly what he should do. And protecting the record, this is smoking all of their appellate arguments. All right, next page we're going to jump to is 25. All right. Now we're back to, and these are kind of jumping around of when these conversations happen, but I wanted to just read a bunch of them. Were you able to speak with your client about her? Is her decision firm? That's what she said to us. I believe this was now after the 30 minutes. Yes, Your Honor. That's what she said to us. The court. All right. Let's have her placed then on the record, and we'll bring the jurors in after I finish printing these pages. Mr. Zellman said, do you want me to have her? Yes. Ms. Dugan, Ms. Fulford, if you can join us at Sidebar. Okay, so now they go back up to Sidebar because, again, we didn't hear this. Just so all the parties were clear on what was just discussed concerning the jury instructions, with there being no lesser included. I don't think I cared to read this. I guess I will read it. Second and third paragraph, the introduction be removed. Okay, here we go. Concerning the matter that previously came up during the sidebar, Ms. Adelson, you remain under oath. As to whether you wish to exercise your right to testify in this trial, have you made a decision considering this? Ms. Adelson, I have made my decision. What is that decision? I am not going to testify. You are firm in this decision? You are firm in your decision. I am. Very well. I will make no further inquiry unless the state or the defense seeks the court to do so. Ms. Kappelman, no, Your Honor. Zellman, no, Your Honor. So this is after everything we heard, everything they did that was in front of you guys, and most of you thought she had plenty of chance and time to do it. After all that, another opportunity to explain that she is firm in her decision. All right, I'm going to jump down a little more. All right, here's another sidebar. As far as our family law expert, we always intended to have her testify. Subsequent to that, we're still trying to make arrangements. Now that we've gotten clarification on the court's position concerning Ms. Descalzo, we're still trying to make arrangements to get her here. So we have, I think, 6 or 7 witnesses for today. This is back now before the defense's case in chief, before all those discussions about Donna Adelson testifying. I don't know how late that will take us. We just were not able to get the other ones here. So between today and tomorrow, you expect for the defense's case to be presented. Yes, we would ask for the court's indulgence tomorrow afternoon so we can have additional time to speak with our client concerning her decision to testify prior to her actually testifying. Obviously, it's her right to decide, and we just want to make sure that she understands everything. The court said, I'm not going to press her on the matter, but this has been an issue which essentially has been from the time of the indictment. Come on. And that's a big eye roll for me. It's like, you decide during the trial. It's a fluid thing. Yes, you're prepared, but it's a big decision you make during the trial. Will you testify at trial? Mr. Zellman, yes. I'm not saying that we have not discussed it with her. The court said, correct. Since almost day one, you will have an opportunity to speak before any colloquy is done concerning whether you will or won't testify. My understanding with the length of the witnesses that we anticipate for tomorrow, we would not be calling her tomorrow if she chooses. It would be Thursday. All right. Concerning that, depending on the defendant's decision, well, it depends. How many witnesses will you have to call on Wednesday? If everything lines up that way, it's supposed to be between 5 and 6. Okay. I certainly will give you a reasonable amount of time. But if, say, we get to lunchtime or a little bit after lunch on Wednesday, if you need a half hour or so to speak to her, I will certainly give that to you. But to recess for the evening, there's been an opportunity to go over this topic for nearly 2 years. You met with her on Saturday as well concerning trial strategy. Saturday and Sunday, yes, Your Honor. All right, I'll give you some additional time in the courtroom, but depending on where we are, falling clockwise, the jurors want to get back to their lives. Yes, Mr. Zellman said. We do need to move this on in a timely fashion. Yes, and there's one final thing I wanted to address at Sidebar. Go ahead, and he didn't put that in here because it wasn't relevant, but this is just to give an example of just how much time and discussion and thoughtfulness Judge Everett put in before we got to, all right, I did more research, I'll give her a little bit more time. So there was ample time, tons of opportunity, tons of notice that we didn't know about, right? I didn't know they said, we're going to do it by this day, or yes, we've already talked to her Saturday and Sunday. Yes, we're going to do this. Yes, the judge is like, I'm telling you, timing lines up like this. So they knew full well how timing lined up, but her right is tantamount, and the defense was correct to argue it, and the judge was correct to eventually give her that more time. All right, let's jump down a little bit. All right, that should put us at timing-wise or less around the same place. Is your client going to be ready to testify tomorrow? Ms. Fulford, it depends on what happens when we speak to the next witness. I suspect that it will be Thursday morning before she'll be ready to testify. Well, not when she would prefer to testify. Ms. Fulford said, I misspoke. The court said, but if we only have this many witnesses, Ms. Fulford said, I misspoke. Go ahead. Because of the evidence that came in the trial and some rulings that the court made, it may affect our decision on whether she wants to testify. And that's true, and that's fair. Mr. Zellman said specifically, there were some additional things that the state added during their case that although we had to discuss the materials, we need to go through the exhibits to see exactly what was admitted in terms of emails and other documents so that we can go over that with Ms. Adelson. So we are going to need a little bit of time to with the clerk to go through that today when the jury leaves. Okay. So they're trying to give an example of some things that they may need to talk to her about. One of the things I can think of is these journal entries, right? They didn't come in other trials, and she's absolutely going to be asked about them. So they need to prep her on them. They may have prepped her on a lot of the things and, okay, what did you mean when you said this? Or what did you mean when you told this to Charlie? Or did you go to Charlie's house or did you not? You can be prepped on a lot of things, but if some new stuff comes up during trial, you still need to be prepared on how you're going to deal with that as the defense attorney and the defendant herself answering these questions. Okay, jump to page 41 here. We're almost done. All right, Mr. Zellman said this afternoon is up in the air, and that's going to require some additional conversation with our client. The court said during the lunch break, that will be your opportunity to have final conversations concerning whether she will, in fact, testify. We'll give the jurors a longer lunch break if necessary to accommodate this. Instead of an hour and 15, it will be an hour and 30. After that, we are going to have to go on the record concerning is she or is she not testifying? Yes, sir. Were you able to speak with her? I will. The short answer is we were allowed 20 minutes during the lunch break. Okay, so this is the colloquy we got to hear in open court when I said I'd give her the night. Think the judge should. She doesn't seem firm. Could be argued it was coerced or not voluntary. You never want that as a judge or as a prosecutor. Unbeknownst to us, the judge did the right thing. I think it was Friday morning at Sidebar when he had those conversations with her. All right, one last chunk we're going to read here before we go to the rest of our weekend. And some of this we heard again, but it's good for context to remember where we're at when we're thinking about what's going to happen on appeal. We are not asking for a lengthy period of time. We originally said that our defense case was going to take 4 to 6 days. We're now halfway through the second day. And all we're asking for is for that to get through the additional witnesses that are today, give us the opportunity, give her that additional time so that she can make that decision so that we are not put in the position where we're looking at potential ineffective assistance of counsel issues before she is. The court said, although you have prepared her, Zellman said, we have, but the decision, it's obviously a serious consequences, whether she exercises her right, exposes herself to cross-examination, or whether she is satisfied with the advice that we are giving her concerning her right to testify. The court, whether it's this afternoon or tomorrow morning, the situation remains the same. She must choose concerning whether she will testify or not. I understand, Your Honor. The court, does the state wish to be heard? Kappelman, my concern, Judge, is that we've told this jury the case is going to conclude Friday, right? 3 weeks. You said the 8th, Ms. Fulford said. Yeah, it finished early. Possibly the 8th, Ms. Fulford. Don't interject. This is the state's opportunity. I apologize, Ms. Fulford said. Yeah, I don't really want to give it to them Friday night. That's a totally fair argument by the state. We've had lots of delays. I do appreciate that it's a very difficult decision, but it has to be made. I don't think it's going to get any easier tomorrow morning than it is this afternoon. So I would ask to proceed and use all the time that we have reserved with the jury as wisely as we can. Totally fair. Usually if I'm the prosecutor, I don't want to push. I don't even want to be heard on this. Like this between the defendant, their lawyer, the judge, not me. The court said, how long do you think the examination of the witness is going to take this afternoon? Zellman said the 2 witnesses, Ms. Newhouse, I think direct and cross 15, 20 minutes are plenty to authenticate and exhibit through her, but not have it introduced, but not publish it. Then Ms. Descalzo, direct and cross. I don't see it going more than 30 minutes, Your Honor. This is starting to sound like an issue as it relates to lack of preparation. You have discussed this with your client. What her testimony would be. To me, when the judge says lack of preparation, I hear ineffective assistance of counsel. But Zellman said, if she testifies, yes, Your Honor. Court said, you have prepared her for the direct and cross. Zellman said, as best we can. Did the best with what we got, Judge. The court, how many times, if you can estimate, have you discussed whether she will testify in this trial? I'm going to have to refer to Ms. Fulford for that. I probably wouldn't answer that. I would say, Judge, that's kind of getting into attorney-client privilege information. I mean, whether she would testify, just that simple subject has come up lots of times, but actually preparing her and going through the evidence, that's been admitted. We're trying to. The court said, this is not about. Fulford said, doing that now. Court said, going through each piece of evidence. Fulford said, I'm not talking. Court said, this is whether she's prepared to testify. Fulford said, well, she has indicated she is not because she hasn't had an opportunity to discuss the evidence with us, what has come in and what needs to be addressed. The court said, Ms. Fulford, how is this case different from any other Florida case where the defendant must make a decision at the conclusion of the state's case? One-day trials happen routinely. Fulford said, right, I understand that, Judge, but this is not a one-day trial. The state, Judge interrupt, no, it has. Fulford said, the state has. Court said, hold on, don't speak over me. There have been multiple opportunities for you to discuss with your client the substance of her testimony, what she would testify to, and we are at the point where it's time to make a decision. This does not sound like a good cause for any further delay. The defendant, may I say something, Your Honor? The court's like, speak to your attorneys. No. Zellman says the question that Ms. Adelson had, the statement is she's asking for the remainder of the afternoon after the other witnesses testify, and so that she will make her decision at that point. Again, seems like they agreed to make the decision at that point, and that's, feeding into the judge's frustrations that, we didn't know about everything. Once the witnesses finish with their testimony, at that time, we will revisit this issue. Concerning whether the direct will start this afternoon is a separate matter from whether she's planning to testify. So that's another thing. It's like she could always say, I'm going to testify. Let's start it in the morning, and then change her mind overnight and say, I'm not going to testify. So the judge really did give them more leeway than it seemed. I need a decision concerning whether she plans to testify at the conclusion of the other defense witnesses. Zellman said, yes, sir. Court said, please return to your table. So I say this all the time. I reserve the right to change my mind. I reserve the right to take in more information and make a better, more informed, appropriate, fair, just decision. The decision that should be made. It's not always the first decision I make. It's not always the first thing I think. It's not always the initial process or thought that I have. And so I respect so much that Judge Everett did the same thing. It was clear he did not think he needed to give her more time. And I understand where he's coming from when we hear some of these sidebars, that he's like, if it's after lunch, we're going to have to do it. She doesn't need to start today, but I need the decision today. You can have the weekend, Saturday and Sunday. You can have this night. You can have that night. When this day comes, you're going to have to talk about it. You can have at the end of the defense's cases, I'll give an extra long lunch. So you can understand why he felt like he gave them more than enough time to have this conversation. And he was like, I'm going to hold you in contempt if you keep ignoring me. I need the answer now. She gives the answer, and she is not firm in her first answer. I think I need more time, Judge. I'd like to talk to my attorneys about it. If I have to answer now, fine, then no. And that answer did not sit right with the judge, which is, inner spirit talking guided him the right direction. He did more research. He didn't have to. A lazy judge wouldn't. A judge that's too proud to second guess anything they say or do wouldn't have done that. This judge is not like that. He went back, did his own research, and changed his mind. I don't care what you say. He changed his mind. He was like, listen, they didn't ask to reopen their case. At least it doesn't seem like they did from the excerpts we've read. He offered it. He was like, listen, I know it's Friday. I know you closed your case in chief. I know you're not supposed to be able to call any more witnesses. I know she said she's not going to testify, but I did some research. And if she wants to testify, most of the appellate courts lean in favor of allowing you to reopen your case. So Ms. Adelson, do you want to testify? No. We talked about it more last night. Even more. He's like, okay, are you firm? She said, yes. Then he asked one more time. Anything else? Need any more time talking to anybody? She's like, actually, if I can get a few minutes. He's like, all right, I'll give you 10. State's like, let's make it 30. He's like, okay, I'll give you 30. She takes another 30 minutes, comes back, says no, she doesn't want to testify, and she is firm and resolute in her decision. Kudos. That is something an appellate court can rubber stamp from Judge Everett. And it makes me feel a lot better, folks. A lot better, because I didn't like it at the time. I didn't like what we heard in open court, and I thought it might be a real appellate issue. The judge fixed it at sidebar, even the next day after. So I'm appreciative of that. Were you guys surprised to see those sidebars? Does it make you more comfortable as far as the decisions that Donna Adelson made? Did you even care in the first place? And I bet it makes you happy that I'm more confident in the ability for this case to be affirmed by the appellate court. But we'll wait and see what the appeal looks like and what happens during the appeal process, because you better believe it's going to happen. All right. I love you guys. Thank you for hanging out with me over the weekend. Make sure you hit that like button. Please subscribe to our channel if you haven't already. That's all we got for this one. But until next time, I'm out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, X, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast featuring new episodes every week. And if you have a case that you want to personally talk to us about in your life, if it's a personal injury case, wrongful death, catastrophic injury, car accident, truck accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.